Welcome, Solid Source. It's Derek Varnado here, and today we're going to take a look at the exclusive seller brokerage engagement agreement. Now, if you are using FMLS Remind Docs Plus, this form is going to be available in the seller package here in Remind. So if you're a Solid Source agent, you have access to broker packages. And in that GAR listing package, we are going to have that exclusive listing agreement. We are going to have frequently used disclosure exhibits such as the seller's disclosure, community association disclosure, etc. So just know that those are available for you here in FMLS. Now, the GAR exclusive listing agreement is one of the most commonly used agreements here in the state of Georgia. It is an exclusive agreement, and that is the type of agreement that requires entry into the MLS. And that is usually the goal for listings. And the GAR listing agreement itself is actually 10 pages, and the blanks are going to be on 4 of those pages. Now, right off the bat here on the exclusive listing agreement, just as a side note, it references OCGA 106A1. That is the Brokerage Relationships and Real Estate Transactions Act, BRETA. And that is the act here in Georgia that applies to all licensees, and it overrides common law of agency and basically says, among other things, that a party is only a client if there is a brokerage engagement in place. And that's what this is today. So this agreement will also create that client relationship with the seller. Now, on the first page, we have our key terms and our conditions, and we are going to start off here by identifying the property. Very similar to the GAR purchase and sale agreement. And we do it here also in 2 different ways. We do it first off by referencing the commonly known mailing address, but that's not enough. We also want to reference the legal description, or a key, where a party could find a complete legal description of the property. Most common method for doing this is to reference the deed book and the page number. Now, the deed book and the page number are typically found within Realist. If you search for that property, you will get to a section on that page called Last Market and Sale History. And typically the deed book and the page number will be referenced there. Now, you can cross-reference that. You can confirm that by individually pulling up the tax assessor's website and searching for that property or that owner. You can also reach out to Sherry Gill at Weissman. She has access to the GSCCCA website. She could always pull a copy of the most recent deed to that property. The great thing about the deed, if you do go that route, you could simply select the first option here, and then the legal description could, for example, be Exhibit A to the listing. But that deed would confirm all parties who have interest in the property, as well as that meets and bounds legal description, the legal description for real property here in Georgia. But definitely the deed book and page number is going to be the most common way to reference that. So pretty simple, right? Now, just a word on townhomes versus condominiums. There is section 4 here, and it does say in bold font, not to be used if property is a fee simple townhome. So a townhome, nothing special is needed, only if it's a condo, because a condo would essentially be an air lot subject to condominium rules and regulations and so forth. So those are going to be different. I do warn everyone, I do warn you guys as agents here in Georgia, the Atlanta area especially, some townhomes, they physically look like townhomes, but they are actually deeded as condos. Now, we should be able to see that. It should be referenced as condominium use in Realist, but just know that that can be the case. If it is, then we would absolutely want to go ahead and select number 4 here, but otherwise, just a standard attached townhome, you would not need to do that. Now, in section 2, pretty simple, you guys, listing price and listing period. So I've already filled in some information here for us. Hypothetically, we're going to list the home at $450,000. Our commencement date is going to be May the 10th. And our end date, the end term for our agreement, will be July the 12th. Now, this is 100% negotiable. I would encourage the commencement date. Typically, that's going to be similar to an offer date when we're filling out a purchase and sale agreement. It's typically the date that we're filling out this listing agreement, the same day that we send it over to the sellers and they sign it. Now, we are required by our license law here in Georgia to include a fixed date of expiration in our brokerage engagement. So we never want to leave anything blank. We never want to have TBD, for to be determined, for any term in an agreement, and especially not the listing agreement. So we definitely do want to go ahead and reference an end date. Marketing, so the MLS systems that the property will appear in. Again, not to harp on this too much, but this is an exclusive listing agreement. So probably if you're not licensed at Solid Source, then definitely check with your broker. But I can say that for Solid Source, we're required to put exclusive listings into the MLS system within 48 business hours. So in this example today, we're going to say that I'm a member of FMLS and Georgia MLS, and the property is located in Fulton County, which is in an FMLS county, and that we're going to put that in both of those MLS systems. So if the goal is to not put the listing into the MLS for whatever reason, please feel free to reach out to your Solid Source broker team. This would not be the agreement that you would want to use, but we can certainly talk to you about that. Maybe the non-exclusive listing agreement would be the way to go. That one, in contrast to this one, is prohibited from MLS entry. There's some other cons, a few cons to the non-exclusive, so it may or may not be the best path to go on. But if the seller doesn't want the property in the MLS, reach out to us and let's talk about that specific situation, okay? So moving on to 3B, which is the marketing commencement date. Now, this is the date that the listing will be active in the MLS. So I know I mentioned a moment ago that we have 48 business hours from the date the listing agreement is signed to put that listing into the MLS. But what if that active date, what if the seller only wants the property to be active maybe a week down the road, right? So we would still put it in the MLS, but we would select the appropriate status. So that may be registered. It might be coming soon if we've had that conversation with the seller and they have agreed that they want to market the property as coming soon for that first 7 days. In an extreme seller's market like the one that we are in today, there may or may not be any benefits to coming soon. Always happy to brainstorm and talk about that with you guys here on the broker team as well. Do keep in mind that when a property is in registered status or in coming soon status, the MLS rules prohibit any showings. So if the property is to be shown when it's in a coming soon or registered status, it would need to be changed to active within one business day. So just keep that in mind as well. And two, you guys have heard me say that when a property is added to the MLS, that's when the magic happens. That's when the property is syndicated to dozens and hundreds of other websites. If you ever Google a listing after you put it in the system, give it a couple days, you're going to notice it show up on lots of other websites, other brokerage firm websites as well. That is through syndication. So a coming soon property won't be pushed out into syndication, but it will be available for other agents to see who log into the MLS and who happen to search based on coming soon, but it won't appear on a lot of those industry leading websites yet until it goes active. When it comes to commission, so how GAR handles commission in their listing agreement is to reference the gross commission, the total commission due from the seller in Section A. And then in Section B, we only reference the portion of A that will be shared with a cooperating broker, a buyer's broker, if any is actually involved in the deal. Now, what about if there's going to be a variable rate commission? What if there's a circumstance that is in place that would decrease the amount of commission that would be offered to another broker? Honestly, not that common, but it does happen sometimes. If that is the case, it would need to be spelled out here in 4C. Perhaps the commission will be less if the listing agent shows the property because the buyer's agent is unable to do that. That is something that sometimes we will see in the MLS. If that is the case, it needs to be very clear here. The seller would need to know about it and agree to that. It would also need to be clearly disclosed in the MLS. When a listing is entered into the MLS, there's a yes or no option for variable rate. Yes would need to be selected, and in private remarks, it would need to be disclosed what the circumstances are surrounding that variable rate very clearly for other agents. Now, a separate commission on a lease. This may be a listing and the seller has no intent to lease the property. Not going to hurt to go ahead and enter in an amount that we would expect if the property leases and some basic terms just in case. Maybe it's going to be a situation where the lease commission is equal to what 1 month's rent would be. Maybe it's equal to $1,500. Maybe that's going to be split. Maybe we expect the seller, the landlord, to pay that within 1 week from the signing of the lease. We could simply spell that out here. Protected period. So the protected period, we have actually already entered in for you if you are a solid source agent and you are following along with me today on this listing agreement. Now, we've put in 365 days. That is what Seth Weissman has recommended. You are welcome to change that if you need to. Maybe the seller wants to negotiate 30 days or 60 days. You can certainly change that. This is the period of time that we would be protected if a buyer that we showed the property to, or we in any way introduced to the property, we procured that buyer, and they purchased the property after our listing agreement had expired. So that is what that protected period is. Now, we'll talk a little bit more about protected period today because the protected period is a little bit of a tricky situation here in the GAR listing agreement. For example, if the listing agreement were to expire and the seller listed with another real estate broker, which is common, we would not be owed any commission at all. So that protected period essentially would be dissolved. So just understand that it's not necessarily a cut and dry issue, but we'll take a look at some of that boilerplate language here in the listing agreement and talk about that too. Now, when it comes to agency and brokerage, I mentioned Beretta when we started off. Beretta does say that we need to disclose to a party the types of relationships that we offer and the ones that we don't offer. So GAR's approach to that is to simply have us select the type of relationship that we don't offer. So that would be dual agency for solid source. We don't offer dual agency. We've gone ahead and marked that for you. If you're pulling the listing from our broker package, that's going to already be selected for you, just making things a little bit easier for you. Now, Section 7A and B is talking about special circumstances. For example, bankruptcy, divorce, maybe there's something beyond that going on, a short sale. As a general rule of thumb, solid source, I want you to reach out to your broker team if you feel that any of these apply, because these are a bit complicated. They can be complicated. We have attorneys on our broker team that are happy to go through those very specific situations with you so we can help keep you in a good place. Because, for example, let's just say it's an estate sale. Now, in general, very basic terms, we understand that an executor or an administrator would need to sign off for the listing for an estate. But there's a process that they go through. So executor means the party who passed had a will. Administrator means that they did not, and it's a court-appointed individual. But it has to go through probate, even if there's a will. Did you know that? So here in Georgia, it would still have to go through the probate process. But again, our attorneys can talk to you about that, and we can help make sure we have everything that we need in place to help protect you up front. And that way, when we have a buyer who is under contract to purchase, everything is going to be perfect and we won't have any unexpected surprises or delays down the road. Now, when it comes to negotiation here in Section 8, seller does. Don't see too many situations where a seller doesn't want our advice, doesn't want us to help them in negotiating that deal. So in almost every case, absolutely, we go ahead and mark does. And at this point, these were the first 2 pages of the 10 pages of this listing agreement. Now, the majority of the other pages, very much like all of GAR's other agreements like the purchase and sale or the buyer brokerage, this other language is what we refer to as that boilerplate language. Just basic standard terms they've got baked in here to help protect everybody based on years of revisions and court cases and all that good stuff. I do encourage you as an agent or as a consumer who is signing off on a exclusive agreement to read this. Do take the time to read it. Be familiar with it. And a lot of what-if situations, default language is going to be built in here. So when there's problems, remember, we go back to the boilerplate language and see what instruction it actually gives us. So I won't bore you by reading all of this, but I do want to talk about some of the initial paragraphs here because they are so good and they do so much to protect us. So the first paragraph is basically the seller is acknowledging that they are not a party to any other listing agreements. And they're acknowledging that if they have unlawfully terminated another agreement and they owe another broker commission, they will be the ones responsible for that. So that's very good for you as a Georgia agent having this listing agreement signed, because of course you would never knowingly sign a brokerage engagement when there was another outstanding brokerage engagement, but in the off chance that there is, the seller is the party who would be responsible for that. So that's spelled out here in the very first section on the top of page 3. Any change to the listing agreement, we can always amend this agreement just like any other contract. Keep in mind, GAR has an amendment to brokerage engagement, and that is the form that we use to amend. So maybe the term needs to be extended. Maybe the seller decides to reduce the price. Maybe the commission's going to change. Whatever that change is, we can use an amendment form and have that signed off on to change the terms. When it comes to the actual listing term, a couple of things that I want you to be aware of. So if the property goes under contract, and the closing date just so happens to be beyond the expiration date of our listing agreement will automatically be extended. So you wouldn't be required to do an amendment to extend the end term, although you could if you feel more comfortable doing that, but you wouldn't be required to do that. Now, for property, if it goes under contract and the closing doesn't happen, you do have the opportunity to unilaterally notify the seller that you are extending the term of the listing agreement by that number of days. But you are limited to your time frame for doing that. So you only have 5 days to inform the seller in writing that you are extending that term. And in no situation can the notice be beyond the expiration date of the agreement, or we're essentially waiving the right to extend the agreement itself. So, and that's basically what this listing agreement is saying here in section 2C. So just keep in mind, if you want to extend it, I would imagine when I see this come up most oftentimes, it's a situation where maybe it's been under contract for 20 days, 30 days, which is a substantial period of time. If it's only under contract for 2 or 3 days, perhaps the buyer terminates while they are in their due diligence period, probably going to be less of an issue. But just know it's not automatic like it used to be years ago, right, in the GAR listing agreement. Those of you who are experienced and have been doing this for a couple of years or more, but now in the listing agreement, you have to unilaterally provide a notice of that extension within those 5 days. So I'm going to fast forward here to page 9 of the listing agreement. And this will be the section of the listing agreement that we can reference any brochures that we are attaching and also any exhibits. Now, in your broker packages, I have included the Protect Yourself When Selling Real Property. Super helpful form. The ABCs of Agency is another very helpful form for explaining brokerage relationships to a party. Whether that relationship be client or customer, this informational brochure goes over all of the different types of agency relationships that are available here in Georgia. Exhibits and addenda, we're going to reference those alphabetically. Lead-based paint, seller's disclosure statement, community association disclosure statement, absolutely the most popular ones. Now, we're required by the EPA, if the property was built before 1978, to include the lead-based paint. We don't have a choice in that matter if it was built before 78. Seller's disclosure statements, though, are absolutely a choice. Now, the GAR listing agreement, in that boilerplate language that we talked about, it says the seller will provide a seller's property disclosure statement or a condensed disclosure statement. GAR introduced a couple of years back a condensed seller's disclosure and fixtures checklist. It's a very short version of the seller's disclosure. So maybe it's an investor, maybe it's a party who's never lived in the home for whatever reason. They don't feel comfortable answering all of those questions on the seller's disclosure statement because there are a lot of questions there. And if you don't know the answers to them, absolutely better not to fill out the form. Maybe you want to go with that shorter version that is available. So if there's not going to be a seller's disclosure filled out, then I would simply add a special stipulation to the listing and just spell that out. Say no seller's disclosure statement will be provided by seller to broker. Now, what about latent or hidden defects? Don't those have to be disclosed? Absolutely. So if there is a hidden defect that a buyer cannot reasonably discover, that the seller knows about or should know about reasonably, if the agent knows about it, we have a duty to disclose it. So we would want to have a seller's disclosure in place disclosing that. And the only other thing I will add about disclosures, you guys, is that if a seller is going to complete a seller's disclosure, they have a duty to keep it updated. So if for whatever reason the property's condition changes, if the seller becomes aware of an issue, maybe as the result of a home inspection that they didn't know about before, they have a duty to keep that seller's disclosure up to date. Now, on the last page of our listing agreement, this is simply going to be where the sellers are going to sign. Please go ahead and enter contact information for the seller. I understand it's not common to list the seller's contact information on the purchase and sale agreement, and you don't have to if there's a client relationship with that seller. But on the listing agreement, absolutely, we want a formal method for communicating to send notice to that seller if we need to, if you need to. And you will also sign as well on behalf of the real estate company. You'll list the brokerage firm that you work for, you'll sign, you'll put your printed name, you'll date it, license number for both yourself and for the brokerage firm that you work for. So hope you found this helpful. If there's anything we can do to help you, maybe you have additional questions about listing agreements, again, we're always happy to look at drafts here on the broker team at Solid Source. So feel free to reach out to us. And until next time, we thank you very much for watching.